Thank you. Be seated. Good morning. Now is the time set for oral argument in Johnson versus, as we colloquially call it, AZROC, AZROC, 1CA CV 160266. For your information, these proceedings are, and I'm sure you both know this, being audio and video recorded. So barring unforeseen problems, and we always point that out first because there is the possibility of it, you can critique the presentation on YouTube in a couple of weeks. Counsel, each side is going to, as is customary, be entitled to 20 minutes, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. An appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know. We will try not to eat up all your time. However, ultimately, reserving rebuttal time is your responsibility. We've reviewed the briefs and conferenced the case this morning, so we are well aware of the facts and issues attendant to the argument. And as I tell everybody, we tell you that so you can figure out, if we've just reviewed the facts and issues, how you can best approach your argument this morning. So please keep that in mind in addressing the court. Counsel, when you come to the podium, I would ask that you state your name and who you represent. With that, the appellant can proceed.
May it please the court. My name is Ryan Dykes. I represent the appellant, Pamela Johnson. The notice of appeal in this case that we are discussing was timely filed with the Registrar of Contractors.
Mr. Dykes, may I ask you a question?
Certainly.
And if this eats into your time, then maybe Judge Jones will give you another minute. In looking at the information provided to the panel as to counsel and who's going to argue this, I didn't see your name.
We sent down the
Did you send in
the form that says who's going to argue. Yeah.
Well, I apologize that the panel doesn't always see that, and the reason why that's important is that it makes sure it allows us to make sure we don't have any conflicts that we might not know about. And I don't, but I wanted to raise it because your name is not shown up. It shows Mr. Porter. And I looked at you and I'm going, that's not Mr. Porter.
No, I'm not Mr. Porter.
Okay.
And I apologize, Your Honor.
No,
we did respond on that form.
We'll follow up. We'll follow up on
Okay.
our end. Okay.
Counsel, go ahead.
Thank you.
Thank you for
So the notice was timely filed with the Registrar of Contractors. It was filed one day late with the Superior Court. And so we have two issues here today. Was the notice of appeal properly filed with the Registrar of Contractors under Section 12-904? And if not, was the notice still timely as being inadvertently filed in the wrong forum under the principles enunciated by this court in Martinez versus Industrial Commission? And it's undisputed that Section 12-904 does not state where this notice is to be filed, nor does the Rule 4 of the procedural rules that apply to these. It just says it needs to be filed within the 30 days or within the time limit. And so we look back to what it was before. This statute used to require, before 2012, the filing of a complaint in the Superior Court. And then that was changed by the legislature in 2012 to a notice of appeal. Now, we know that complaints are filed in Superior Court, but notices of appeal in every appellate proceeding I could locate are always filed with the forum that makes the decision that's being appealed from. And since the change of the language by the legislature is presumed to have some meaning, and since notice of appeal is a recognized term, we assert that it's reasonable to conclude that the notice of appeal in Section 12-904 should be filed like all other notices with the forum that issued the decision.
Counsel, when did you realize that you had filed it in the wrong place? When?
Thank you.
You filed it in the Superior Court.
Yeah, it was eventually filed in the Superior Court. I was not involved in the case at the time.
Does the record support when it was noticed and why it was? They realized they had filed it in the wrong
There's
court.
nothing in the record that gives you the why. Your Honor. All the record shows is that it was filed later. I believe it was a belts and suspenders type thing, uncertainty as to where to file it. And so there's once the notice is filed, there's another.
I'm assuming that the filing fee was paid.
Correct.
And it does say the filing fee is supposed to be paid in the Superior Court.
That's correct.
And when was the filing fee paid?
I do not have the date. I imagine that's in the record, however, because the filing fee was paid.
Contemporaneous with the filing of the notice
Correct.
of appeal?
Yeah. And so when we look there at 90.
Back up. Was there ever an attempt to pay the filing fee when you lodged your notice of appeal with the registrar?
I do not believe so, but I don't know that, and I don't know what the record reflects on that.
I don't think there is anything in the record that reflects that Ms. Johnson, through counsel or otherwise, attempted to make a monetary filing fee payment to the registrar for filing in Superior Court.
I didn't find anything either. That's why I was asking you if you found it.
No, I
If you're
didn't find
aware
it.
of anything.
I do not know that. I can't give you that fact.
In looking at the legislative history, what little there is, about the change in eliminating the word complaint to the word substituting appeal, I didn't see anything that suggested that there was any type of meaningful thought given that would somehow have a significant change in practice. Did you find anything?
No, I didn't find anything one way or the other, but when they're making a change of language, this is one of those statutes that it seems like it's always been missing something.
Well, there's a lot of statutes like that. But let me ask you, let's assume for the moment that is something that has some type of moment to it or some type of significance. But the legislature didn't change a number of other provisions. For example, Section 12904B requires an appealing party to file a notice of the action with the agency that conducted the hearing within 10 days after filing a notice of appeal. If you file your notice of appeal with the agency, then that's completely redundant. You've already given the agency notice that you appealed. Why then do you need to give them another notice that you've appealed? See, they didn't make that change.
No,
And
they
there are
didn't.
other statutes like that that would require basically just duplicative effort.
I think you're correct, Your Honor. There are things that weren't changed. I personally don't believe that there was a lot of thought given to the changes in the statute. But it's still.
By whom, counsel?
Pardon?
By whom?
Plead the fifth.
Yeah,
Don't
this,
say.
yeah.
But what happens is, by making a change, we introduce uncertainty into what used to be, at least current practice was pretty clear that we filed a complaint in the Superior Court. We always file complaints in Superior Court. And suddenly when you get the change of language, we have an uncertainty that's introduced. What do you do? And I think that the statute should be interpreted so that it doesn't create a minefield, as this court said in Martinez, where you have to go through looking at different sections to try to figure out where to file this.
What would you, let me ask you about that. I agree with you that on its face, 904 does not expressly require the notice of appeal or the document to prosecute the appeal to be filed in the Superior Court. It no longer expressly says that, or it ever did. But then what about the interaction or the effect of the Arizona Rules of Procedure for Judicial Review of Administrative Decisions? They apply.
Yes, they do.
And they incorporate by reference the Arizona Rules of Civil Procedure for the most part. And as incorporated, Arizona Rule of Civil Procedure 3 says a civil action is commenced by filing a complaint with the court. So we have, if there is a silence there, we are supplementing that silence with our procedural rules.
Yes. The Rule 4 of the Rules of Procedure for Judicial Review of Administrative Decisions, again, does not tell us, that would seem to be the place where the court would say, file it here, as they've done in every other appellate situation I know of. They give a specific spot in which to file your notice of appeal. But it doesn't. Rule 4 just says the appellant's notice of appeal shall be filed within the time required and shall be captioned, et cetera, and so forth. It doesn't tell us, again, where to do that. And I think that interpreting the statute to say, well, you should just know, or you should look at a number of other rules to figure out where to file this, even though none of them specifically say where to file a notice of appeal. And 904 does talk about an action being commenced, but then you have this notice of appeal language. And again, I just think it creates an uncertainty where an uncertainty is not warranted. And the
Well,
statute.
if we, and I don't disagree with your starting point, but we have to look at the entire legislative scheme, it seems to me. And if we do that, for example, there's 1290, it's the venue provision. It's, I think it's
905B.
Yeah,
905.
905B. That says venue shall be of any action commenced in the Superior Court, venue shall be, and goes on. So if you put this legislative scheme together, isn't there enough there to direct a careful practitioner where to file?
I don't think so. I think that still, I just think it's unclear. And I understand where you're coming from, and I understand that, which will bring me to the next part of my argument.
Before we get there, I had one other question
Sure.
on this. Before the legislature amended this statute, when it used the word complaint, do you believe then it was sufficiently clear that that complaint was to be filed in the Superior Court, or did it suffer from the same uncertainty?
I think it still suffered from the same uncertainty. Why can't we just say, if you want judicial review, here's where to go and do it, instead of leaving it up? I will speak from my experience just as an older lawyer now.
Oh, we're not that old. Wait.
Well, maybe I'll look.
Seasoned.
Speak for yourself.
Seasoned.
Okay.
Seasoned, all right. Very well.
We're
But,
seasoned. Okay.
the first time I did an appeal from an administrative decision, I actually consulted other lawyers to find out where to file it. I looked at the statute and I asked somebody else, where do you file this? So to answer your question, I don't think it was clear back then. I don't think it's clear now. But I do want to get to my other argument before my time expires, which is that even if the notice was required by the statutory scheme to be filed in the Superior Court, then I believe that this court has already set the rule for what happens when you file your notice of appeal in the wrong forum. And that's in the Martinez case. In the Martinez case, that involved a special action to the Court of Appeals, but the special action was filed with the Industrial Commission instead of the Court of Appeals. And the Industrial Commission moved to dismiss the case on grounds that it was not timely filed, similar to what we have here. And the court said, we're going to look here at the rules that apply to these special actions. And among other things, this court looked at Section 12-120.22 and Rule 4 of the Arizona Rules of Civil Appellate Procedure, and determined that under the provisions of that statute and that rule, that the notice of appeal, since it was timely filed, even though it was filed in the wrong location, it should be considered as having been timely filed in the right location, and jurisdiction it should exist, and the case should be decided on the merits.
Counsel, are you saying then that the rule should be that if you don't know what to do something? Because it's up to the courts then to straighten it out?
I think that the quintessential threshold requirement for appeals is that deadline. Whatever deadline is set, and you have to file something then. I think the rule, and it's even stated in Martinez, it's an inadvertent filing. It's not just willy-nilly do whatever you want to do. It's you make an effort, you file it, turns out to be the wrong place. We're not going to dismiss your appeal for that reason. I think that's the rule, Your Honor. And I think it's already in existence under Martinez.
Your argument with Martinez and Wilkinson is a good one. But what troubles me is that in both cases, it was the presence of what was then RCAP Rule 4 that allowed for some wiggle room, for maybe some ability of the courts to address the problem of the inadvertent filing in the wrong judicial forum. But we don't have anything like Rule 4 in either the statutes or the rules for the govern administrative appeals. We just don't have that base to help build, and we really are, administrative appeals are a creature of statute, and we can't go in and fill a void unless we have something to work with.
The Section 12-914 incorporates all the rules that apply to appeals to the Supreme Court. And so I think you do have an avenue there, and the statute hasn't changed. 120.22, 12-120.22 has not changed.
But how does that apply here?
Well, it applies because it says that when you file in the wrong forum, it won't be dismissed. If it's timely filed, it will not be dismissed. Just for
on its face, it doesn't apply to administrative appeals.
No, and that was addressed in Martinez.
And that's because then the court looked at Rule 4, the RCAP rule, and we don't have an RCAP rule that applies in this situation.
When was the RCAP rule? I apologize for asking this question. When was it taken on?
The current RCAP 4 was modified substantially, I believe, in effective January 1, 2015, or in 2016. So it no longer even has this provision in it any longer.
Well, again, I think we have to go back to the underlying theory of Martinez, which is we don't want to create minefields here. We've got a statute that's unclear and really is difficult to comply with when it could be clear, and the rules could be clear, and to tell us where it's filed. And so that's, I will try to reserve the remainder of my time if there's no other questions right now.
Thank you, counsel.
May it please the Court, Thomas Rain on behalf of the Arizona Registrar of Contractors. We're here to ask that the Court affirm the Superior Court's dismissal of this judicial review action because the Superior Court did lack subject matter jurisdiction due to the undisputed fact that Appellant Johnson did not commence an action for review of the administrative decision until a day after the statute had expired. The Registrar contends that the Judicial Review Act is clear when read in totality as to where to file.
We have to kind of sort through it, don't you? I mean, Mr. Dykes makes a powerful point from a practical standpoint. Someone should be able to look up and turn to a statute and says, you file here. And there's nothing that just says directly, you file here. You have to kind of piece it together.
It's pretty circuitous, isn't it, counsel?
Yeah.
You have to go to one or two or a couple other places just in order to put together the discussion or the dialectic as to where you're going to file a notice of appeal?
I would say to you, one would look at 12-904 and 905, and from reading those two together, it is clear that the only place one could file an appeal where the Judicial Review Act would make any sense is in the Superior Court.
So all we need is 12-904, 905, and we're home.
Correct. And then when you look at all the other statutes read in pari materia, if one was to find that you filed in the administrative agency, I'll go through them, but several other statutes, as Judge Norris pointed out, make no sense and are completely duplicative. So if I could mention, if we look at 904A, an action to review a final administrative decision shall be commenced by filing a notice of appeal. As we mentioned in our supplemental briefing, an action is commonly understood and is held by this court to be a case within a court, not the administrative proceeding. So an action is commenced by filing a notice of appeal. Going to 905B, the venue statute, it mentions an action to review a final administrative decision may be commenced in the Superior Court. So an action is filing a notice of appeal. That notice of appeal is commenced by filing in the Superior Court. Nowhere in there does it state filing with the administrative agency. And even looking at 904 A and B, even reading those statutes consistently, there could be only one conclusion, and that's to file in Superior Court. So 904 mentions an action to review a final administrative decision shall be commenced by filing a notice of appeal. 904B states, within 10 days after filing a notice of appeal pursuant to this article, the party seeking judicial review shall file a notice of the action with the Office of Administrative Hearings or the agency that conducted the hearing. So, as Judge Norris mentioned, it would be a very strained reading to require someone to file a notice of appeal with the agency and then to let the agency know 10 days later that we just filed a notice of appeal with you. Then if you go look at...
Before you move on, given your notice of supplemental authority and the argument you just made about how the word action refers to a court case or
Yes.
a Superior Court matter. Subsection B1 says the record, basically on appeal, shall consist of the following. The original agency action for which review is sought. Does that kind of muddy the waters on what is the clear and well understood definition of what action is?
Give me a moment. I want to get the full statute here. 4B1. The record shall consist of the following: the original agency action. Yeah. I hadn't considered that, Your Honor, but it potentially could muddy the water, but not, again, when you're looking at A and B together in totality, it is still clear that...
the word action by itself is maybe not as crystal clear as we'd like.
Maybe, but that was just a little bit of icing on the cake to an extent, because, again, it's still, if I go back to 905, which is the venue statute, it clearly states under 905A, jurisdiction to review a final administrative decision is vested in the Superior Court. And there's another, one of the JRAD rules, or the rules of judicial, the judicial review of administrative decision rules. We spoke about a few of them in the appellant's case, but if you look at Rule 2, reading that, it's also clear that the Superior Court is the forum to file notice of appeal. So Rule 2 of the Judicial Review of Administrative Decisions rule states, I'm going to read it in part, the Superior Court may extend the period of time prescribed either by these rules or by yada, 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 including the time for filing a notice of appearance or the record on review, but it may not extend the time for filing of a notice of appeal pursuant to 12-904. So that's using the phrase notice of appeal and indicating that the Superior Court may not extend the time for filing that. So that's another indication.
Rule 2?
Rule 2.
Yeah.
So that is another indication that the appropriate and only appropriate forum is the Superior Court to file the notice of appeal. And stop me, Your Honor, if I'm kind of going over ground you've already covered, but looking in, if we review all the statutes together in the Judicial Review Act, if one was to find that the notice of appeal should be filed with the administrative agency, not only 904B would be rendered duplicative, where you file the notice of the action with the same agency where you filed the notice of appeal. In 12906, you're supposed to file a copy of the notice of serve a copy of the notice of appeal on the agency. Again, that would be the third time they would get it. And then 907 states within 20 days after service of the notice of appeal, the appellee agency shall file a notice of appearance in response to the notice of appeal. So that would mean if we're stating that the notice of appeal is filed with the agency, maybe the agency would even be read to be filing a notice of appearance with itself. And as the court mentioned, even with the filing fee, if this court was to find that the agency was the place to file it, who pays the filing fee? There's nothing in the Judicial Review Act that would give an agency any guidance as to what to do with a notice of appeal once it received it. It doesn't state how many days the agency would have to then commence the action in Superior Court. What if the notice of appeal is somehow deficient? Would the agency would they have any responsibility to gatekeep for that? So there's just nothing in the Judicial Review Act that would give the agencies any guidance as to what to do in the case of receiving a notice of appeal. I'd like to discuss Martinez a little bit. Even if Rule 4 of the Rules of Civil Appellate Procedure did apply, the Rule 4 has been substantially changed, as the court was mentioning either 2015 or 2016. According to my research, it was January 2015 was when Rule 4 was amended. And Martinez relied on Rule 4 and ARS 12-120.22b. So the former version of Rule 4, which permitted the Court of Appeals in Martinez to reach that decision, was much broader than it is today. So the old version stated, no papers received by the clerk within the time fixed for filing, which if untimely filed would render the case, appeal, or petition subject to dismissal by the appellate court for jurisdictional reasons, shall be refused by the clerk solely for the reason that they were not tendered for filing in the proper court or division. So in Martinez, the Court of Appeals, they looked at the Industrial Commission and stated, well, it's acting in a quasi-judicial capacity, so we're going to call it a court for purposes of Rule 4, and that's how the Court of Appeals reached that decision in Martinez. The current version of Rule 4, which would apply to this case, is much more narrow in terms of where the incorrect filing can be corrected. So the current version states, if a party timely submits a document for filing in an incorrect appellate court or appellate division, the appellate clerk must deliver the document to the appropriate appellate court or appellate division. So even if Rule 4 applied to this case, the current version would not help the appellant unless this court is ready to find that the Registrar of Contractors is an appellate court. And Martinez also relied on 12-120.22b, but that statute by its terms only applies to actions brought in the Court of Appeals. So that would not apply to an administrative decision. If I could mention one thing about the legislative change, there was, following the legislative change to the Judicial Review Act in 2012, this court decided the M11 Limited Partnership versus Gomard case. That was in 2014. And in that opinion, the court did cited the current version of the statute that contains notice of appeal. And the Court of Appeals in that case went back and forth 4 or 5 times, interchanging the phrase complaint for judicial review, notice of appeal. They even used it if one files a complaint or a notice of appeal. So that indicates, at least at that time, the Court of Appeals wasn't of a mind that that was a major change in the statute. They used those terms interchangeably. And interestingly, in the M11 case, it was very similar factually to this scenario. So in M11, someone was appealing a Department of Transportation decision. They mailed their notice of appeal to the Superior Court, and they also mailed a copy to the department, to ADOT. The record was clear in that case that ADOT had received the notice of appeal prior to the deadline, but the Superior Court didn't get it till 8 or 9 days later. And the actual issue in the case was, can they rely on the mailbox rule to get there? But implicit in that ruling, the Superior Court had the facts right in front of it, where it could have applied a Martinez-like savings clause, or even found that under the Judicial Review Act, that the notice of appeal filed with the Department of Transportation was sufficient. But the court didn't do that. The court instead looked at the mailbox rule and concluded it did not apply, and remanded back to the Superior Court for fact-finding, and it stated the only way this notice of appeal is going to be considered timely filed is if the Superior Court received it prior to the deadline. I think I shall reserve the remainder of my time if you don't have any questions.
Do you happen to know whether the registrar, either on his website or perhaps has a publication that tells parties to an administrative appeal where they're supposed to file their notice of appeal?
Your Honor, I don't know that, but if that's significant to the court, I could find that. I have people behind me that would probably tell me, but we can submit a supplemental brief if that's something the court would like to know. But I will comment that the registrar adjudicates a lot of cases, and they get a fair amount of administrative appeals, and this is the first time that this issue has come up where someone has made an argument that you should file with the administrative agency. So people are doing this out in the world and getting it correct all the time.
Yeah, and is that in fact true? People are getting it right all the time. You don't get people filing notices of appeal with the Registrar of Contractors itself?
No, we do get on occasion, and this sort of goes in favor of not finding that the administrative agency is the appropriate forum. Registrar does receive things, an angry email after an administrative decision, or someone sending a fax or saying, hey, this is, I disagree with this decision. I'm saying all kinds of things, but it's We do not receive documents entitled Notice of Appeal where it is not then filed in Superior Court. That's, to my knowledge, I've been with the registrar about 2 years and that hasn't happened. But,
So we're clear on this. The Industrial Commission has a series of internal appeals processes. There's nothing like that with the Registrar of Contractors.
so the Industrial Commission, as I understand it, they have their own judges. They have their own system from A to Z. So you would get a hearing. I think you have a hearing with an officer, then you get a judicial hearing within the administrative context, and then they can even review, reject, or modify. So it's all one-stop shop. The registrar, all of their hearings go to Office of Administrative Hearings. So OAD makes a decision, and then the registrar, within 20 days, modifies or rejects or accepts the decision.
So effectively, by filing the notice there would be no anticipation that it would handle the notice itself. The best it could do would be a repository for a notice of appeal that was then going to be heard by the Superior Court.
That's my understanding, yes, Your Honor.
Well, what did you do with the notice of appeal in this case when it was filed with you, or lodged with you, I should say?
In this case, the registrar, I don't think they did anything with it. The actual notice in this appeal was a little confusing. The original notice that was sent to the registrar prior to the deadline, it named Maricopa County as an appellee, and it was a little ambiguous. And the registrar, and then ultimately they filed the correct notice a day late, and the registrar, ultimately the Attorney General's office, we filed to dismiss the case, but nothing was done. To my knowledge, no one called the appellant and notified them what to do with it. And all of that sort of counsels against finding that the agency is the appropriate place to do it, because it puts a lot of responsibilities on the agency where the agency has no guidance as to what to do with these things, especially where the notice of appeal is somehow ambiguous or not clearly or appropriately stated. The lower court of appeals, they have their own judge, they have their own clerks, and they're geared up and expecting these kind of documents.
But most of that is something that's unknown to an otherwise unwary filer, correct? They don't know that you don't have the mechanism for handling that. They don't know that you don't have the internal mechanisms to process that on to another agency or to the courts, correct?
That's true, Your Honor, but ultimately the Judicial Review Act is set up how it's set up, and if one wants to perfect an appeal, one is charged with reading the Act. It's not a long document. I mean, it is ARS 910 to 914, but it's probably about a few paragraphs in total of actual text. If one reads it in totality, or even just reading 904 and 905, it's clear that that's the only place to file is the Court of Appeals. Again, and we even have where do you file the jurisdictions in the Court of Appeals, the filing fee is paid in the Court of Appeals. All of these signs point to filing in the Court of Appeals. And even the appellant in this case, I'm saying Court of Appeals, in the Superior Court. The appellant in this case, even, they did it correctly, they just did it a day late. So even the appellant in this case did figure it out, they just missed it by a day.
Thank you.
Thank you.
Argument's been made that allowing the notice to be filed with the Registrar of Contractors would create a redundancy. I'd point out that redundancy has always been there. 904B requires notice to be given to the agency, and then 906 requires that the notice be served in the manner of process, being served by a process server. So there's always been multiple notices that have been given.
But not based on filing the notice of appeal. Well, forgive me, that wasn't very clear. The redundancies, there may well be redundancies, but they come later in the process. They are not redundant of filing. First, you have to file a notice of appeal. It has to go somewhere. Filing a notice of appeal with the agency and then giving the agency notice of the appeal is truly redundant because they've already got the notice of appeal. And the other redundancies you've mentioned come a little bit later in the process.
Well, they come right after that.
Well, yes, but...
I mean, it's something that has to be done right away. It has to be done, and that triggers the agency's duty then to file a notice of appearance for something that they've already gotten notice of.
Well, but isn't there a difference in those two items, counsel?
I don't
mean,
know.
and you're talking about the notice of the initiation of the action and then their notice of appearance. I mean, if they choose to default on the appeal, they can do that. They don't have to file a notice of appearance and show their face in the matter.
But they could,
that's different.
but they could default in that manner, Your Honor, simply by getting the first notice and just doing nothing. But the statutory scheme requires that they be given notice and then that they be served with process.
Well, that's true, because they have to, the agency has to prepare their record. But all of that builds and is required, the agency, excuse me, if a party files their notice of appeal of the administrative decision and they do it with Superior Court, and that's all they do, the agency will not know that there is an appeal that has been triggered. So the notice provisions in subsection 12904B are designed to put the agency on notice. You need to get the record ready.
Your Honor, maybe that's correct with some agencies, but in this case, the record is prepared by the Office of Administrative Hearings, and that's what goes in. It's not the registrar preparing the record on appeal.
Excuse me, you're right, yeah.
And so that's not triggering anything at that point. I'm just pointing out that there's a redundancy. There's always been a redundancy in the statute, and the redundancy that we've talked about now should not be a reason to interpret the statute to eliminate an appeal under these circumstances. That's my only argument. I only have less than 2 minutes here, so I'd just like to say one other thing, which is the argument was made that the Superior Court is not an appellate court or appellate division under the current Rule 4. I think that Martinez is still good law, and that the Superior Court functions in almost every important aspect as an appellate court. The function is there. They receive a record. They don't retry the case like we do with a complaint. We don't have a trial. We have an appeal with a record, and then the record's considered, and the court can deal with the record the way they modify it or affirm it or do something else with it, just as an appellate court would do.
So you would say that what happened here was a parallel, for instance, from a non-record court to the Superior Court.
Exactly. Yes. And I would also point out that the Martinez court relied on 12-120, point 22, and had this to say: RCAP Rule 4A and the statute referring to Section 120.22 refer to an appeal filed in the incorrect court or division. Although the ICA is not a court and it is an administrative agency and not a court, it acts as a quasi-judicial body, and so does the ROC. They act as a quasi-judicial body, just like the ICA. They determine facts, they apply the law, much as a court would do. And so I think that Martinez is still good law, and it should be followed here. I think that the two policies that are competing here is the finality. You got to file on time, but once you've filed, I think that you've met that, and now you can. Your appeal should not be dismissed simply because it was filed in the wrong location. Thank you. My time's up.
Thank you, counsel. No, that's good. Thank you. We are going to take the matter under advisement at this time. Counsel, we do appreciate your oral argument. We do have issues that arise during the course of conferencing, and it does help if we can sit here and kind of air them out and vet them in a way that gives us a little outside thought on those issues. So thank you so much for that. As I say, we're going to take it under advisement at this time, and we will issue our decision in due course. Thank you very much. We're adjourned.